to from 2006 to 2011, 114% increase in driving fatalities involving drivers testing positive for marijuana. Comparing 2007 through 2009 with 2010 through 2012, a 37% increase in drug-related suspensions and expulsions from Colorado schools, a sharp increase in marijuana exposure to young children, many resulting in trips to poison centers or hospitals, and in the words of the Colorado's Attorney General, the state is becoming, quote, a significant exporter of marijuana to the rest of the country. The statistics on this point are shocking but not surprising, given simple economics. From 2005 to 2012, there was a 407% increase in Colorado marijuana interdiction seizures that were destined for other states. In 2012 alone, there were interdictions in Colorado bound for 37 different states. One of those states was my home state of Iowa. In 2010, Colorado was the source state for 10% of all marijuana interdiction in Iowa. That number grew to 25% 2011 and to 36% 2012. Now, this was all before full legalization in Colorado. What do you think this number will be next year? Is the federal government prepared to pay for law enforcement costs it is imposing on states like Iowa because it refuses to enforce federal law? In 2012, the proportion of Iowa juveniles entering substance treatment primarily due to marijuana reached its highest point in 20 years. How many more of Iowa's daughters and sons will go into treatment next year because the department won't enforce federal law? There's no amount of money that can make Iowa whole for that. I have a letter from the director of the Iowa Office of Drug Control Policy to the Attorney General that lays out some of these statistics. The director requested that the department consider this decision, and I ask that that be included in the record.
Without objection.
Of course, the department would have known many of these things had it consulted with the folks on the ground before making those decisions. These are people who see the effects of marijuana addiction and abuse every day. I also have here a letter to the Attorney General from many of the major state and local law enforcement organizations in the United States, and likewise asked to put that in the record. I understand representatives of many of these organizations had asked to be consulted in advance of the department's decision, but they were told that they would be. However, they wrote, quote, "It is unacceptable that the Department of Justice did not consult our organizations, whose members will be directly impacted, for meaningful input ahead of this important decision. Our organizations were given notice just 30 minutes before the official announcement was made public and were not given the adequate forum ahead of time to express our concerns with the department's conclusion on this matter. Simply checking the box by alerting law enforcement officials right before a decision is announced is not enough and certainly does not show an understanding of the value of the federal, state, and local tribal law enforcement partnerships bring to the Department of Justice and to public safety." End of quote, and I'll put the rest of my statement on the record.
Thank you very much. And our first witness is James Cole, as I said, the Deputy Attorney General of the Department of Justice.
We just heard from Grassley, the senator from Iowa, ranking member, and Lively Libra, our Iowa panelist, is up there shaking her head. She's so mad she can spit right now. We return you back, and we'll talk to Libra after the panel.
1979, and served for 13 years in the criminal division. Later became the deputy chief of the division's public integrity section before entering private practice. Mr. Cole, it's always good to have you here. Please go ahead, sir.
Thank you, Chairman Leahy, Ranking Member Grassley, Senator Whitehouse. I'm pleased to speak with you about the guidance that the Department recently issued to all United States attorneys regarding marijuana enforcement efforts. That guidance instructs our prosecutors to continue to enforce federal priorities, such as preventing sales of marijuana by criminal enterprises, preventing violence and the use of firearms in the cultivation and distribution of marijuana, preventing distribution to minors, and preventing the cultivation of marijuana on public lands. priorities that we historically have focused on for many years. And it also notes that we will continue to rely on state and local authorities to effectively enforce their own drug laws as we work together to protect our communities. As you know, the relevant federal statute, the Controlled Substances Act of 1970, among other prohibitions, makes it a federal crime to possess, grow, or distribute marijuana, and to open, rent, or maintain a place of business for any of these purposes. For many years, all 50 states have enacted uniform drug control laws or similar provisions that mirrored the CSA with respect to their treatment of marijuana and made the possession, cultivation, and distribution of marijuana a state criminal offense. With such overlapping statutory authorities, the federal government and the states traditionally worked as partners in the field of drug enforcement. Federal law enforcement historically has targeted sophisticated drug traffickers and organizations, while state and local authorities generally have focused their enforcement efforts under their state laws on more localized and lower-level drug activity. Starting with California in 1996, several states authorized the cultivation, distribution, possession, and use of marijuana for medical purposes under state law. Today, 21 states and the District of Columbia legalize marijuana for medical purposes under state law, including 6 states that enacted medical marijuana legislation this year. Throughout this time period, the Department of Justice has continued to work with its state and local partners, but focused its own efforts and resources on priorities that are particularly important to the federal government. The priorities that have guided our efforts are as follows: preventing the distribution of marijuana to minors, preventing revenue from the sale of marijuana from going to criminal enterprises, gangs, and cartels, preventing the diversion of marijuana from states where it is legal under state law in some form to other states, preventing state-authorized marijuana activity from being used as a cover or pretext for the trafficking of other illegal drugs or other illegal activity, preventing violence and the use of firearms in the cultivation and distribution of marijuana, preventing drugged driving and the exacerbation of other public health consequences associated with marijuana use, preventing the growing of marijuana on public lands and the attendant public safety and environmental dangers posed by marijuana production on public lands, and preventing marijuana possession or use on federal property. Examples of our efforts have included cases against individuals and organizations who were using the state laws as a pretext to engage in large-scale trafficking of marijuana to other states, enforcement against those who were operating marijuana businesses near schools, parks, and playgrounds, and enforcement against those who were wreaking environmental damage by growing marijuana on our public lands. On the other hand, the Department has not historically devoted our finite resources to prosecuting individuals whose conduct is limited to the possession of marijuana for personal use on private property. In November of 2012, voters in Colorado and Washington state passed ballot initiatives that legalized under state law the possession of small amounts of marijuana and made Colorado and Washington the first states to provide for the regulation of marijuana production, processing, and sale for recreational purposes. The Department of Justice has reviewed these ballot initiatives in the context of our enforcement priorities. On August 29, 2013, the Department notified the governors of Colorado and Washington that we were not, at this time, seeking to preempt their state ballot initiatives. We advised the governors that we expected their states to implement strong and effective regulatory and enforcement systems to fully protect against the public health and safety harms that are the focus of our marijuana enforcement priorities, and that the Department would continue to investigate and prosecute cases in Washington and in Colorado in which the underlying conduct implicated our federal interests. The Department reserved its right to challenge the state laws at a later time, and in the event of any of the stated harms materializing, either in spite of strict regulatory scheme or because of the lack of one, we reserve that right to preempt. That same day, the Department issued a guidance memorandum to all United States attorneys, directing our prosecutors to continue to fully investigate and prosecute marijuana cases that implicate any one of our 8 federal enforcement priorities.
Getting some buffering here on the video player. Should return in just a moment. See if we can refresh this and get a better connection. You're listening to 420 radio coverage of the Senate Judiciary hearings on state marijuana legalization. The Deputy Attorney General
to the enforcement of their own drug laws. This updated guidance is consistent with our efforts to maximize our investigative and prosecutorial resources in this time of budget challenges, and with the more general message the Attorney General delivered last month to all federal prosecutors, emphasizing the importance of quality priorities for all cases we bring, with an eye towards promoting public safety, deterrence, and fairness. Our updated guidance also makes one overarching point clear. The Department of Justice expects that state and local governments that have enacted laws authorizing marijuana-related conduct will implement effective regulatory and enforcement systems to protect federal priorities and the health and safety of every citizen. As the guidance explains, a jurisdiction's regulatory scheme must be tough in practice, not just on paper.
Thank you. You know, what I worry about, to the extent that we have some who do not take the position or are unwilling to follow it, may create further problems. For example, the banking industry is not willing to provide services to state-authorized marijuana dispensaries. They fear they may be violating federal money laundering laws. So then they start operating as a cash-only business, no access to bank accounts or credit card transactions. That's a prescription for problems, tax evasion, and so on. And we're hearing that the DEA agents, and what seems to me like a significant step away from reality, are instructing armored car companies to cease providing services to marijuana dispensaries, almost as if they're saying, yeah, get out there so we can have some robberies. Now, I'm sure it's not stated that way, and maybe sometimes, whether it's DEA or anything else, bureaucracy trumps reality, as it has in this case, but it creates a problem. So what's the department going to do to address these concerns? What sort of guidance are you giving to states about these banking and tax issues?
Chairman Leahy, as far as the banking issue is concerned, we agree it is an issue that we need to deal with. When the Attorney General talked to the governors of Washington and Colorado, they raised the same issue, and others have raised the same issue. Obviously, there is a public safety concern when businesses have a lot of cash sitting around. There is a tendency that there's guns associated with that, so it's important to deal with that kind of issue. And we're at the present time talking with FinCEN, and they're talking with and bringing in bank regulators to discuss ways that this could be dealt with in accordance with the laws that we have on the books today.
May want to talk with DEA, too.
As far as DEA is concerned, Mr. Chairman, I certainly had heard about that. From what I understand, DEA was merely asking questions of the armored car companies at the time as to what their practices are. I think those questions occurred before the guidance memo was put out, and certainly at the present time, I don't believe there's any effort to instruct the armored car companies not to do anything at this point.
Well, that implication is out there, and I would hope that it get cleared up, because I don't want to see a shootout somewhere and have innocent people or law enforcement endangered by that. So I think it should be specific guidance to the financial services industry or the Treasury Department. Now, you've noted the Department generally does not prosecute individuals who are using small amounts of marijuana on private property, which I think is sort of the general attitude of most state prosecutors. They've usually got real problems to deal with and not that. Instead, the Department has targeted sophisticated and large-scale drug traffickers. They've relied upon state and local law enforcement to go after lower-level drug activity, although they're usually overwhelmed with things that really affect people. In the wake of the recent guidance, we've heard some concerns the federal government is abdicating all responsibility for enforcing drug laws in Colorado or Washington State, and that the department's decision will lead to free-for-all of drug activity in those states. I assume you do not agree with that characterization that the Justice Department is abdicating its responsibility for enforcing federal drug laws in those states.
I don't agree with it at all, Mr. Chairman. I think it's quite the contrary. What I think is very clear in our memo is that we are going to aggressively enforce the Controlled Substance Act when it implicates any of the 8 priorities that are listed there. And I think that's a pretty fulsome list of priorities of important public safety issues that are present and associated with marijuana. We expect to continue to enforce in every state whenever that is implicated, whether the state has a state law legalizing it or not. We are not giving immunity. We are not giving a free pass. We are not.
Live coverage of the Senate Judiciary hearings on marijuana legalization in Colorado and Washington, the effect and conflict between state and federal law. Refreshing the buffer here. Many people are tuned into this right at the moment, so we're having trouble sometimes getting a feed as all these people are hitting this. We're getting a lot of tweets from all of the organizations. We'll see if we can connect now.
Way that's going to be attractive to minors, we're going to go after them. If we see somebody who's growing and cultivating marijuana so they can import it or export it out of state, we're going to go after them. If they're involved.
Again, buffering issues here at the 420 radio studios. Lots of people hitting this feed now as the word spreads of this committee hearing. We still have our live panel watching from all across the United States. We have members of our audience from Iowa, from Missouri, from Georgia, Colorado, New York, and right here in Oregon. Still waiting for a refresh on the feed, but so far we have heard the Deputy Attorney General being questioned about the DEA's order not to allow armored car companies to work and banks to work with dispensaries. The Deputy Attorney General assured the committee that they are working
on the
with bank
regulatory
regulators.
Framework set by them, but not on question telling them what they have to criminalize.
We're having some bandwidth difficulties again trying to hit this up. I'm going to disconnect our live panel so that we can free up some bandwidth, and we will reconnect with all you guys as the hearings conclude. Thank you for joining us here, and we'll see if we can refresh.
Mr. Cole, I have 3 questions, but before I do that, I want to take 30 seconds out of my own time to bring an issue up that I think you can help us with. The DEA is refusing to comply with its legal obligations to provide GAO access to DEA records. Senator Whitehouse and I have a GAO request for a report on drug shortages that is being delayed because DEA's refusal. I tried to help resolve the issue, but the Justice Department told DEA not to even meet with me and GAO to discuss it. So I think that's unacceptable. I understand that you admitted to the Comptroller General that DEA has a legal obligation to comply. However, the Justice Department and DEA are still withholding records from the GAO. There is no point in wasting time and the taxpayers on litigation with GAO, but that is where this is headed if DEA does not comply. So, as Deputy Attorney General, I hope you can help us to work with us in Congress to solve this dispute. DEA needs to provide GAO the information it needs to do its work. I don't expect you to.
Our apologies for the trouble with the bandwidth. Again, the Senate usually doesn't get a ton of people watching these things, and I think this one is probably overloading their servers to an extent they're not used to.
And I am on top of this, Senator.
God bless you. The Cole Memorandum suggests that the Department won't seek to enforce the Controlled Substances Act except to enforce certain federal priorities so long as the states that legalize marijuana implement effective regulatory schemes. Those priorities include the diversion of marijuana from Colorado to other states, increased use among minors, and increased facilities from drug driving. Yet Colorado has seen a sharp uptick in each of these three priorities over the past few years. Moreover, a recent audit concluded that Colorado Department of Public Health, quote, does not sufficiently oversee physicians who make medical marijuana recommendations, end of quote. Another recent audit found that the city of Denver did, quote, not have a basic control framework in place, end of quote, to regulate its medical marijuana program. Denver did not even know how many marijuana businesses were operating in the border. So, question, why has the department decided to trust Colorado to effectively regulate recreational marijuana when it is already struggling to regulate medical marijuana and federal priorities are already being negatively impacted? Before you answer, would the department establish metrics concerning these priorities that will trigger when it will take action to either challenge these laws or more vigorously enforce federal law? I want to give you an example. 2005 to 2012, there was a 407% increase in Colorado marijuana interdiction seizures that were destined for other states. How high would that number have to go to trigger a change in policy? I hope this is something that you've thought about.
Senator Grassley, we've thought a great deal about these issues. I'm certainly aware of the audit that was done in Colorado about the enforcement of their regulatory scheme under medical marijuana, and it was it was disappointing. I think along the lines of what I had talked to Chairman Leahy about, there are no perfect solutions here. And what we were faced with was a situation where we couldn't, we thought, be very successful in trying to preempt the decriminalization. So if we just went after their regulatory scheme, instead of just having a bad one, they'd have no regulatory scheme. Our hope is that with this memo and with the engagement with the state, telling them that they are, as we say, trust but verify, that they will have an incentive to actually put in a robust scheme that will in fact address a lot of these issues that you've raised and everyone else has raised and that are valid issues in this area. And we're hoping that that kind of effort by the state in enforcing its own state laws will have a better effect than having no effort whatsoever. So I understand the skepticism that you come to it with. We are looking at it in terms of a trust but verify method. We will be following what's going on. We have reserved quite explicitly the right to go in and preempt at a later date if we feel that that's in the public interest. And I think we're at a point now where we're trying to find the best of the imperfect solutions that are before us.
Question number two, you heard in my opening statements how the department did not consult with major state and local law enforcement groups or with former DEA administrators when reaching policy decisions. Did the department consult with anybody at DEA, HHS, or State Department about these policies? And if not, why not? And if so, what were their views?
Well, we did consult with HHS. We consulted with DEA, ONDCP. We even heard from many of those groups who wrote that letter. The Attorney General and I this morning met with those groups in the Attorney General's conference room for about an hour.
Having some buffering on the feed from the Senate Judiciary hearings. Deputy Attorney General James Cole is testifying before the committee. Just recently mentioned that this was the best of imperfect solutions.
Hour and a half. We had received a lot of input from them concerning this matter prior to the decision that we made. We stated to them quite clearly today that we should have reached out to them one more time before we made the decision, and we apologize to them for not making that extra effort. We believed that we understood their position.
Again, many people hitting this Senate feed, so there will be some buffering issues. My apologies.
Crystallize and articulate in our 8 different areas what it is uniformly throughout the country that we think are the problems that trigger federal enforcement in this area. So we thank them for that.
My last question. In 2010, Colorado was a source of state for 10% of all marijuana interdiction in Iowa. That number grew 25, 2011, 36%, 2012. This is all before legalization of recreational use in Colorado was passed. In the words of Colorado Attorney General, the state is becoming, quote, a significant exporter of marijuana to the rest of the country. The department's decision not to enforce federal law is obviously imposing costs on states outside of Colorado and Washington. These include public health costs, law enforcement costs. I would normally ask this question. I'm going to make a statement if I'm wrong. I doubt if the federal government has plans to reimburse the states for these costs. If I'm wrong on that, tell me. My question, what do you plan to do to protect states like Iowa from marijuana diverted from states like Colorado?
I think there's 2 ways that we're hoping to approach this. One is that if the states really do put in the kind of robust system that we're asking them to, where there's control from seed to sale, that it will help really tamp down that kind of export out of Colorado into other states. And secondly, and at least as importantly, one of the main priorities we have is the export of marijuana from states that make it legal to any other state. And that will be a federal enforcement priority. If it's being exported from Colorado to Iowa and we find out about it, we will prosecute it.
Mr. Chairman, just a short follow-up. You, in the previous question, second question I had, you said you consulted with state HHS and DEA. Did they agree with the new policy that you have announced?
You know, Senator, we had a thorough discussion with them. I don't think it's always appropriate to go into what the internal deliberations are that take place, but we got everybody's views and we had a thorough discussion and aired it out. And this was a well thought through process.
Thank you.
Thank you.
White House.
I'm going to get any room.
Thank you, Chairman.
And I'll be back.
Mr. Cole, let me just kind of recap what brought us to this point, because I don't think we were in a very good place to begin with. I begin with the Ogden memorandum from 2009, which indicated that it would not be a federal enforcement priority to prosecute, and I quote, individuals whose actions are in clear and unambiguous compliance with existing state laws. And then it gave as an example individuals with cancer or other serious illnesses. As another example, or those caregivers in clear and unambiguous compliance with existing state law. It then distinguished commercial enterprises that unlawfully market and sell marijuana for profit. And a close reading of the paragraph indicates that the term unlawfully refers to state law, because the following sentence talks about operations inconsistent with the terms, conditions, or purposes of those laws, meaning state laws. So we come out of the Ogden memorandum with protection from federal prosecution for patients, caregivers, and lawful commercial enterprises that are, quote, in clear and
Live coverage of the Senate Judiciary hearings, having some buffering from their server. See if we can refresh.
And we're hoping that that kind of effort by the state in enforcing its own state laws will have a better effect than having no effort whatsoever. So I understand the skepticism that you come to it with. We are looking at it in terms of a trust but verify method. We will be following what's going on. We have reserved, quite explicitly, the right to go in and preempt at a later date if we feel that that's in the public interest. And I think we're at a point now where we're trying to find the best of the imperfect solutions that are before us.
Question number 2, you heard in my opening statements how the department did not consult with major state and local law enforcement groups or with former DEA administrators when reaching policy decisions. Did the department consult with anybody at DEA, HHS, or State Department about these policies? And if not, why not? And if so, what were their views?
Well, we did consult with HHS. We consulted with DEA, ONDCP. We even heard from many of those groups who wrote that letter. The Attorney General and I this morning met with those groups in the Attorney General's conference room for about an hour and a half. We had received a lot of input from them concerning this matter prior to the decision that we made. We stated to them quite clearly today that we should have reached out to them one more time before we made the decision, and we apologized to them for not making that extra effort. We believed that we crystallize and articulate in our 8 different areas what it is uniformly throughout the country that we think are the problems that trigger federal enforcement in this area, so we thank them for that.
My last question. In 2010, Colorado was a source of state for 10% of all marijuana interdiction in Iowa. That number grew 25, 2011, 36%, 2012. This is all before legalization of recreational use in Colorado was passed. In the words of Colorado Attorney General, the state is becoming, quote, a
memo, low those many years. But let me just be clear. As long as they are not the proper subjects of federal prosecution under the 2013 memo federal interests, a dispensary can do business as long as it is in clear and unambiguous compliance with state law, correct?
I think the proper way to phrase it, Senator Whitehouse, is as long as they are not violating any of the 8 federal priorities in the course of what they're doing, that the federal government is not going to prosecute them. And the state law is up to state law and up to state enforcement.
Understood.
But there also is, just in all fairness, there is a catch-all at the end, and it's not meant to swallow the entire memo, but you can't anticipate everything that's going to come into the future. So there's an ability, if it's an important enough matter that we hadn't anticipated, to prosecute another kind of case, even if it doesn't fall within the 8 priorities.
Understood. And those who receive proceeds from a lawful and proper state law enterprise will also not be prosecuted unless they violate one of the 8 federal interests.
This is something that we're trying to work through with the banking regulators, because the memo really talks about the Controlled Substances Act. Now, the prosecution otherwise on the banking end would be the money laundering statutes, and those, I think, are a separate matter, but one, as I've said, in answer to Chairman Leahy's questions, ones that we need to deal with. There's a lot of public safety and public interest aspects of that I think we need to deal with as we go down this road, and we're working on that.
But you're not intended to put people who are simply getting their bills paid by a proper, lawful state law enterprise from being the subject. It's not your intention that they be the subject of prosecution. In the same way that if you knew it was a criminal cartel and you, no matter what your business is, the proceeds of that cartel carry some taint with them, and you can go after individuals just because they receive money. You can, if nothing else, reclaim the funds as the proceeds of criminal activity. You're not intending to use that unless those 8 federal interests are implicated.
I think that's part of what we're trying to work through right now in trying to deal with the money laundering aspect of it. But certainly this memo is meant to guide our enforcement efforts concerning marijuana in regard to the Controlled Substances Act, and it'll probably spill over in other ways as we're trying to work through them.
And similarly, property owners, landlords, and financiers should not fear federal prosecution unless they implicate those 8 federal interests.
Certainly a lot of that is covered by the Controlled Substances Act, so that will be directly within the ambit of the memo. That's correct.
Okay. Well, I think that helps clarify things. Senator Grassley raised a number of concerns relating and I thought from hearing them that all of them fell into the category of either involving children or involving effects in other states or involving a relationship with trafficking organizations. And just to be clear, it's my understanding that in all three of those situations, those are federal interests that would be implicated, and the federal government would be willing and able to prosecute in those areas.
That's correct.
Thank you. My time's expired.
Thank you, Mr. Chairman. Thank you for having this hearing on a subject vitally important to my home state of Connecticut. As you know, our law, a new law, currently allows the production and sale and use of marijuana for medicinal purposes in a regulatory regimen that I think is fairly straightforward and complete, and certainly indicates the will of our legislature and our state that Connecticut wants to move in the direction of providing legal access to this kind of substance. Essentially, it decriminalizes statutes so that anyone found in possession with less than half an ounce of marijuana will be subject to a citation rather than criminal action. And it, I think, mirrors other state laws that contain similar kinds of provisions. I don't want to speak for the Department of Justice, but my guess is there are very few cases authorized by the Department of Justice that involve simple possession of small amounts of marijuana currently. That has been the ongoing practice for some time, has it not?
I think that's correct. And from what we heard from the state and local law enforcement organizations this morning, they say there's very few of those under state law as well.
Right. So that current practice will not be altered by anything in the memorandum as I read it.
That's correct.
And in terms of some of the other priorities, my assumption is that the enforcement efforts there on individual prosecution cases would depend to some extent on the amounts of marijuana involved, would they not?
That's certainly a factor that's taken into account. It's not the sole factor.
Would the resulting, and I apologize if this question's been asked, action by the Department of Justice, if there were not enforcement in some of these areas, involve a challenge to the statutory scheme, and how would that be brought, or would it involve individual prosecution cases, and how would you make those decisions?
Well, we did briefly talk before about, in response to Chairman Leahy's question, what the legal mechanisms would be to challenge the state laws. And first of all, you start off with the Controlled Substance Act has in its body itself a disclaimer of preempting state laws in the area. So that's explicit in it. So you would only have it if there's a conflict that is unreconcilable. When you have a law that decriminalizes marijuana, it's a very big challenge.
Areas involve a challenge to the statutory scheme, and how would that be brought, or would it involve individual prosecution cases, and how would you make those decisions?
Well, we did briefly talk before about, in response to Chairman Leahy's question, what the legal mechanisms would be to challenge the state laws. And first of all, you start off with the Controlled Substance Act has in its body itself a disclaimer of preempting state laws in the area. So that's explicit in it. So you would only have it if there's a conflict that is unreconcilable. When you have decriminalization of marijuana and not even a legal structure for the state to try and regulate it, and that's not a very good solution either. None of them are very good in this field, frankly, but that seems to be one that takes you in the wrong direction.
So the Department of Justice, as I understand your answer, would be very cautious and deliberate about any challenge to a regulatory scheme because the results might do more harm than good.
We're going to have to look at all the facts and circumstances that come up. We've certainly put the governors of Colorado and Washington State on notice that we expect them to have robust systems. We hope that all the other states that have medical marijuana or any other sort of legalized system will view this memo as it should be taken, as telling them they ought to have a robust system to regulate the marijuana usage under their own state laws so that they deal with these 8 priorities, which we think are important. And then we'll make our decisions as we see what kind of public interest issues are raised in the course of this and what the need is for us to take action.
I understand that the memo deals only with the Controlled Substances Act, but there are also provisions of the tax code that forbid deduction of expenses by some of these enterprises, non-criminal enterprises, dispensaries, and others engaged in medicinal marijuana businesses. Has the Department of Justice taken a position on changing the tax code to make those legitimate businesses eligible to deduct common business expenses?
We have not taken a position on a change of legislation. We think that's something that the United States Congress should probably, in its wisdom, take up and debate and determine what the appropriate course of action should be.
But it would probably be consistent with your memorandum to have those expenses deducted as long as none of the other priorities are infringed on.
Well, our memorandum is really focused on what the federal enforcement will be of the Controlled Substances Act. There are obviously other issues that spin off of that do need to be dealt with, and I think those are the kinds of things that the Senate and the House can debate and determine if there's an appropriate policy change to be made.
And finally, let me ask you about Connecticut. Have there been consultations with Connecticut officials about the implementation of that law?
Not that I'm aware of right now, but the U.S. Attorney there, I'm sure, has been in touch with them, but I'm not positive.
Thank you. Thank you, Mr. Chairman.
Thank you very much.
Mr. Chairman?
Mr. Coulter, yes.
Can I make one point before Deputy Attorney General is excused? You have 3 prosecutors, former prosecutors here, and so we clearly appreciate the flexibility that it's important for prosecutors to have, and we clearly appreciate the discretion that prosecutors enjoy and that should be protected by the department. But at the same time, I think the department would be well advised to listen to Senator Grassley's advice about trying to establish as clear metrics as you comfortably can, because there can be a lot of unintended consequences from the broad zone of uncertainty that you can create, and that can frankly be quite harmful in and of itself. So I think in this area, and particularly with respect to the regulatory regimes and what you would expect to approve and disapprove, the more you can move towards the kind of metrics that Senator Grassley recommended, I think the better off you'd be. I speak only for myself in that, but I think that's my advice anyway.
If I may add, Mr. Chairman, I would second what Senator Whitehouse has just said, particularly as Senator Grassley has pointed out some of the banking implications in Connecticut. My understanding is that some bankers are reluctant currently to be involved with marijuana business because they are fearful about violating federal law. And the clearer and more definitive you can make your expressions of prosecutorial policy, I think the more helpful it will be to them, insofar as they're aiding legitimate businesses, not criminal enterprises, not businesses selling to minors and others who may violate your priorities. So I would second what Senator Whitehouse has just said. Thank you.
Thank you.
Thank you very much. And Mr. Cole, thank you very much.
Thank you, Mr. Chairman.
And we'll call up Sheriff Urquhart, who is the King County Sheriff. Jack Finlaw is the Chief Legal Counsel of the Office of Governor Hickenlooper. And Kevin Zabet, who is the co-founder and director of Project SAM.
You're watching the live coverage of the Senate Judiciary hearings on state marijuana legalization.
Sheriff Urquhart is the elected sheriff of King County in Washington State. He's the sheriff of the state's largest metropolitan county. So I think he's particularly qualified to help us here. Sheriff Urquhart has been in law enforcement for more than 35 years. He's been a patrol officer, field training officer, master police officer, street-level vice narcotics detective, public information officer, administrative aide to several sheriffs. And Sheriff, would you go ahead and give your statement? Incidentally, all statements, I'm advised we may have another Syria meeting, but all statements will be placed in the record in full. You'll also be able to, when you see the record, if you want to add to things you've said, you have a chance to do that. So I'd ask you to summarize within the 5 minutes your statement. And I hate to say it, Sheriff, because I know you and others have traveled some distance to get here, and I appreciate you being here. Sheriff, go ahead.
Thank you, Mr. Chairman. And at the risk of stating the obvious, I am a police officer. Thank you for having me here today. My name is John Urquhart. I'm the sheriff of King County, Washington. Seattle is located in King County, and with almost 2 million residents, we're the 14th largest county by population in the United States. I have over 1,000 employees in the sheriff's office and a budget exceeding $160 million. As sheriff, I am therefore the top law enforcement official in the largest jurisdiction in the country that has legalized marijuana. Now, I've been a police officer for 37 years, and I was elected as King County Sheriff last year. During my career, I've investigated everything from shoplifts to homicides. But I've also spent almost 12 years as a narcotics detective. My experience shows me that the war on drugs has been a failure. We have not significantly reduced demand over time, but we have incarcerated generations of individuals, the highest incarceration rate in the world. So the citizens of the state of Washington decided it was time to try something new, and in November of 2012 they passed Initiative 502, which legalized recreational amounts of marijuana and at the same time created very strict rules and laws. I was a strong supporter of Initiative 502 last year, and I remain a strong supporter today. There are several reasons for that support. Most of all, I support 502 because that's what the people want. They voted for legalized marijuana. We, the government, have failed the people, and now they want to try something else. Too often the attitude of the police is, we're the cops and you're not. Don't tell us how to do our job. That's the wrong attitude, and I refuse to fall into that trap. While the title of this hearing is the conflict between state and federal marijuana laws, I don't see a huge conflict. The reality is we do have complementary goals and values. We all agree we don't want our children using marijuana. We all agree we don't want impaired drivers. We all agree we don't want to continue enriching criminals. Washington's law honors those values by separating consumers from gangs and diverting the proceeds from the sale of marijuana toward furthering the goals of public safety. In legalizing and regulating the possession and sale of marijuana, is it a better alternative? I think it is, but I'm willing to be proven wrong. The only way we will know, however, is if we are allowed to try. DOJ's recent decision provides clarity on how we in Washington can continue to collaborate with the federal government to enforce our drug laws while at the same time respecting the will of the voters. It's a great step, but more needs to be done. And I hate to beat a dead horse here, but for example, we are still limited by not knowing the role of banking institutions as we go forward. Under federal
clearer and more definitive you can make your expressions of prosecutorial policy, I think the more helpful it will be to them, insofar as they're aiding legitimate businesses, not criminal enterprises, not businesses selling to minors. And
collaboration with the DEA, FBI, and DOJ for robust
buffering our coverage here. A lot of people hitting this internet link from the Senate, so it takes us a little bit of time sometimes to get everything booted up. We've got our live chat going on as well with our selected members of audience. who are giving us some of their commentary as this goes on here. You're listening to the live coverage of 420 Radio's coverage of the Senate Judiciary hearings on the state and federal conflict on marijuana laws.
Voted on and adopted by the citizens of the state of Washington and the guidance provided by the Department of Justice on August 29th. Mr. Chairman, I say to you and the members of this committee, I do appreciate the deference the federal government has shown to my constituents, and I look forward to continuing that cooperation. Thank you.
And we'll come, I'm going to have each of the witnesses testify, and then we'll go to questions, but certainly testimony based on 35 years' experience in law enforcement is extremely helpful. Mr. Finlaw is the Chief Legal Counsel for the Governor of Colorado, John Hickenlooper. He served as co-chair of the task force that recommended legislation and rules to implement Colorado's new constitutional provisions legalizing the possession, use, sale of marijuana in the state. Thus has a unique perspective of the challenges facing states. They deal with the conflict between state and federal marijuana laws. And I believe prior to your current position, you were Chief of Staff to the Mayor of Denver. Is that correct?
That's correct.
Thank you. Please go ahead, sir.
Thank you, Chairman Leahy, Ranking Member Grassley, members of the committee. I have been working for the past 10 months with a really large collection of Coloradans, stakeholders, government officials, members of the marijuana industry to put together
Buffering the feed again.
what we will affirm to you is a robust and strong enforcement regime. You know, the voters of Colorado approved what we called Amendment 64 in 2012 by about 55% of the vote, even though the governor, the attorney general, state leaders opposed.
Again, sorry for the delays here and the stops. The feed is buffering from the Senate Judiciary hearings on the conflicts of state and federal marijuana laws. We will keep this feed up as best we can, but again, with so many people hitting it, there are a lot of buffering delays that we have to deal with.
Amendment 64, the governor, our attorney general, got on the phone with General Holder and began this conversation about this conflict between federal and state law. And although we just recently, as we've talked about today, received official guidance, we do want to recognize that General Holder, the Justice Department, our U.S. Attorney, was very forthcoming about expressing federal law enforcement's concerns about this new legalization effort, and it really allowed us to focus our efforts to develop a robust and regulatory and enforcement regime for marijuana in Colorado. One of the things we did, besides passing bills to regulate the industry, we enhanced tools for law enforcement by passing a new law that gives law enforcement the ability to better address the issues of impaired driving. We now have a law that provides that if a driver's blood contains 5 nanograms or more of THC, there's a permissible inference that the driver was driving under the influence. You know, we really appreciate the collaboration we've had with federal officials. We know we have more to do. As been discussed today, we have audits critical of some of the things we've done in the past to address. I will say that the main reason that we've had failures of regulation of our medical marijuana industry is because we've lacked the resources to hire staff and partner with law enforcement. But we are sending to the voters this fall a marijuana tax measure that will provide the kind of revenue we need to hire staff to also work on public health issues related to marijuana and education and prevention efforts that we are determined to focus on. The bottom line is we commend the Department of Justice for this guidance that they've issued in the new Cole memo. We think it was, for us, timely clarification because we were in the final weeks of doing our rules, and so we got it in time to make sure that our rules complied with the enforcement priorities outlined in the Cole memo. We actually affirm and embrace those 8 priorities, and we look forward to working with the federal government, our Department of Public Safety, our local law enforcement. We'll work with federal law enforcement. We have a great working relationship with our U.S. Attorney, and I think that you'll discover that not only will Colorado's regulators and law enforcement want to partner with federal law enforcement, but the industry will as well. One of the things I've discovered in working on marijuana issues over the last 10 months is how entrepreneurial, how much integrity the folks in our state that have developed these new businesses have. I mean, I would compare them to folks that you've all met as you've toured wineries in Napa or gone to distilleries in your state, Mr. Chairman. I know they make some great rye whiskey in Vermont. These are the same types of folks who have established medical marijuana dispensaries, grow operations in Colorado, and they will be partners with us in making sure that minors don't have access to marijuana, that the marijuana doesn't flow to Iowa or other states. I think that we look forward to a very successful regulatory regime, and I will echo the Sheriff's comments and other comments we've heard today about the banking issue. It's both a law enforcement issue and a regulatory issue, and also the tax issue. So we look forward to working with our members of Congress to address those issues.
Well, thank you, Mr. Finlan. And without objection, I'll also put in the written testimony of Washington Governor Jay Inslee and Washington Attorney General Bob Ferguson in the record. Their views are also important and relevant. Our next witness is Kevin Sabet, who is the co-founder, did I pronounce that correctly?
Yeah, perfect.
Co-founder and director of Project SAM, or Smart Approaches to Marijuana, and the director of the Drug Policy Institute at the University of Florida. Previously served in the Office of National Drug Control Policy in various capacities, written extensively about this topic. Please go ahead.
Thank you, Chairman Leahy, Ranking Member Grassley, and distinguished members of the committee for providing me with the opportunity to appear before you today to discuss marijuana policy. As mentioned, I've studied, researched, and written about drug policy for almost 18 years, and currently am the director and co-founder with former Congressman Patrick Kennedy of Project SAM, Smart Approaches to Marijuana. Because we share the Obama administration's drug control goals of reducing drug abuse and its consequences, I and dozens of prevention, treatment, medical, and scientific groups around the country found the recent guidance by the Department of Justice disturbing on both legal and policy grounds. The guidance, which expressly defers the department's right to challenge and preempt laws legalizing marijuana, contradicts the Controlled Substances Act both on the policy and legal level, especially policy principles designed to protect public health and safety. Colorado and Washington have now become and have now been given the green light to become the first jurisdictions in the world to allow for the creation of large, for-profit marijuana entities, far surpassing any reforms in Europe. Now, I think I should mention that the Controlled Substances Act is an important tool for public health. In fact, by keeping marijuana illegal, its use is a sixth and a third lower than alcohol and tobacco, respectively, in the United States. I applaud the way the Controlled Substances Act has been used so far by the federal government, not to go after low-level users with an addiction problem, but instead to target drug traffickers and producers. This is not about putting marijuana smokers in jail. In fact, analyses has long debunked the myths that our prison cells are full of people whose only crime was smoking marijuana. Indeed, as a side note, if we were today to let out every single person in the United States for any drug offense, our incarceration rate in the U.S. would be 4 times its historical high, not 5 times. Still a massive incarceration problem, regardless of drug offenses. Now, we do not have to wait for legalization to happen. For several years, many states like Colorado have been operating with a de facto legalization policy under the guise of medicine. In fact, we can get, and anybody who's been to Colorado since 2009 can get a sense of full legalization. Mass advertising and promotion, using items that are attractive to kids, whether they are medical marijuana lollipops, ring pots, pot tarts to mimic Pop-Tarts, are all characteristics of current policies. The result, as mentioned, has been an increase in drug-related referrals for high school students, more intense